Hello, everyone, and welcome to the Civility is the Core of Your Successful Career webinar. This program is brought by the ABA Law Student Division, the Center for Responsibility, and the Lawyers Division. I'm Erik J. I'll be serving as your moderator today. I am a little bit about me. I'm a journalist from New York. My wife and I moved down to Atlanta in 2015, and I am now a 2L at Georgia State University. I'm the deputy student editor at the ABA's Student Lawyer Magazine, which is the publication for the Law Student Division of the American Bar Association. Joining me today is Jayne Reardon from the Illinois State Commission on Professionalism. We are going to go over a little bit about a reminder today about the ABA membership. We just want to tell folks that all students can upgrade from their free membership to the premium membership for only $25. If you aren't already a law student member of the ABA, I highly encourage you to do that. That's free. That's in law school can join. And then if you want to expand your horizon, as it were, you can, for $25, join as a premium member. Some of the benefits that are available as a premium member include a discount, $50 off of Baldry Review, $25 off at Web Academic, a professional ethics bundle, a professional responsibility bundle, and also a free resume review. I think it's, as a broke law student, I understand everyone's tight for cash, but for $25, I think it's really worth it. It's something that is very helpful, and the $250 for the ball prep alone, I think, is worth it. So, that being said, I'm introducing Jayne, who will be presenting today. Jayne Reardon. Jayne, why don't you tell us a little bit about yourself before we start our presentation?
Thanks so much, Erik, and thanks everyone for joining. Before I launch into my background, I just want to tell you that I couldn't agree with Erik more, that joining the ABA as a law student is great value, and it is so important to become connected with other professionals across your geographic area and across the country. You will find that the relationships you make in the ABA will really augment those from your law school and serve you so well. So many times over the many years, I have called on people that I would not have known but for my membership in the ABA. So I have been a lawyer for, well, over 30 years. From the University of Michigan, I was a trial lawyer for a number of years. For the last 10 years, I have been the executive director of the Commission on Professionalism that was created by the Illinois Supreme Court with an eye to promoting civility and professionalism. So, let's start with civility and why it's important for lawyers. As you know, or you may know, lawyers were the main signers of the Declaration of Independence. More lawyers than any other profession have been presidents of our country. They populate our House, our Senate, etc. In fact, there are only 0.4% of our population nationally are lawyers, yet we are outsized, represented in leadership positions across our state and federal governments. So given the history of lawyers, you would think we would be well perceived, right, by having a positive reputation. In fact, not so much. The Illinois Supreme Court Commission on Professionalism did a survey of all Illinois lawyers in 2014, and these survey results actually are similar to the results of other surveys that have been done. Over 4,400 lawyers responded, and 85% said they had experienced uncivil or unprofessional behavior, usually by other lawyers, in the last 6 months. Our survey kind of dug into what types of behavior they were talking about, and it generally fell into 3 categories: prejudice, rudeness, and what we've called strategic incivility. So Prejudice is ageism, sexism, racism, and as you would expect, it was experienced primarily by young lawyers, by women, and by minorities. 38% said they'd experienced just general rudeness, which is so unfortunate. One of the respondents said, some people, especially lawyers, are just jerks. And the third category, the one that was actually most troubling to our Supreme Court and our commission, was strategic incivility. This was the Rambo litigation tactics. This was the lawyer who refused to accommodate reasonable requests for to change something to fit in their schedule. This was misrepresentations of the facts in pleadings or what have you.
Jayne, just to interject for a second, I'm curious about this strategic litigation or strategic litigation practice. Are there any areas in particular that where you see that happening more? I know recently I wrote an article on civility for Student Lawyer magazine, and had more than one attorney tell me that they've seen particularly poor behavior from lawyers in depositions. I'm just wondering if that's something that you've noticed as well.
Yes, that is a prevalent area of incivility, Eric. In fact, the other areas are on telephone calls and emails, texts, and written communication. But the deposition point was very interesting, and we know this is strategic. It's planned out by lawyers with the idea they're hoping to gain an advantage, because if the deposition was videotaped, the incidence of incivility dropped by half. And the significance of that means if it's videotaped, a judge can review the behavior and decide whether or not the objections were fairly taken or the behavior was appropriate. So if somebody's going to look at the lawyer's behavior, they're going to behave better, which is really quite unfortunate. And you know, there's some significant consequences to this. The lawyers who responded to this survey, and you can see the results on the slide, readily admitted that by acting in an uncivil or unprofessional way, it made it more difficult to resolve a matter, and it led to increased costs to their clients, harms the public confidence in the judicial system, and you know, it made the practice of law less satisfying. That's a very significant finding by 92%, because I do a lot of programs with our lawyers' assistance programs, and lawyers are more than twice as likely as a general population to suffer from substance abuse and mental illness, and even suicides, because there's in some cases a disconnect between what they thought they were going to be doing as a practicing lawyer and what they actually end up doing. So let's talk about what we mean when we're talking about civility. And the root of the word relates to citizens. And the ancient Greeks thought this would require people to behave in good relation with one another, and it was good for the city-state. So it was a personal virtue and a public need and a public necessity. And it's the same root that comes from our Civil Rights Act, or the Civil Rights Movement. And George Washington talked about it in terms of respect, right? In saying, every action done in company ought to be with some sign of respect. As you may know, George Washington wrote the rules of civility way back in the beginning of our country. So civility and respect are all kind of the cornerstones of being a professional, being a lawyer. And as practicing lawyers, you're going to learn that professionalism has a lot of different aspects, right? And it's not necessarily definable in 10 words or less. It depends on the circumstances. It also has changed over time. What was the status quo when I started practicing law was the women must wear a suit with a skirt. That is not required to be a professional today.
And Jane, do you have any kind of practical examples of what this might look like?
Yeah, so let's tick through some of those practical examples. And, you know, they're pretty basic stuff, which is treat all your coworkers with respect. Your coworkers, your classmates, etc. It's important to understand, particularly when you're just starting out in a field, that someone who might be on a lower level, if you will, a secretary or an assistant, actually is invaluable to advance your career because they have information and institutional knowledge, and you can't get all hung up with what status position you have. You have to remember that you're all in a service industry working together. You might experience that in law school already.
Yeah, I was going to interject there, Jane. I agree. I think taking your classes seriously and kind of knowing that even what you do in law school, as crazy as it may seem, even what you're doing in law school does reflect on your character. And people, whether rightly or wrongly, are going to see what you do and kind of judge you about it. I've talked to people who have run into professors or deans at schools out in the real world and have, the top of someone who acts unprofessionally in class, either, showing up late or not being prepared, not reading, and being a pattern of that. Those kinds of things, people do talk, and even something that you may not think is a big deal, like being late to your civil procedure class every Monday morning, it can be a big deal and it can come back to bite you. So, I mean, I would just be cautious and realize that once you're in law school and you're starting your journey down your career for the legal career, people are watching and people notice what you do.
Yeah, there are so many times where I was contacted by a law school classmate who I might not have had any interaction with for months or years, and was able to get some business, to able to refer some cases. So in fact, the relationships you're building now and the reputation you're building is really, really important. Another point is something that's not stressed in law school, at least back when I was in law school as much, as listen first. There's a lot of trial advocacy classes, and you're taught to give a presentation and argue persuasively, etc. But a really, really important skill to being a civil and a professional attorney is to listen. And not only when you're listening, not only when you're supposed to be listening, but also, in a more casual setting. I find it's very frustrating because I'm a little bit of a fast talker to keep my mouth shut and not interject and fill in someone else's sentences, or to not steal a look at my phone if I'm a little bit bored by somebody who's long-winded. But those kinds of skills really do send a signal that you care and that you're professional. There's another one. This is kind of basic. Avoid negative talk about others, but it's very tempting, especially if you're in your first or second law job. If it's a big organization in particular, you might be around someone who's going to trash talk somebody else at your level, above or below, and it's good to just kind of stay away. I don't know whether you've experienced that even in law school.
Yeah, Jane, I was going to ask you about that as well. I think everybody sees a little bit of that in law school. People have obviously talk, but I'm curious. I think a lot of students obviously aim to get summer jobs, whether it's clerkships or working at a firm. What do you recommend a law student does or a young lawyer does if that happens at work over the summer?
Well, what I find works really well for me is humor, right? You don't want to say, well, I would not talk about someone that way. That's not very nice, because then you're going to be dissed as a goody two-shoes or somebody who has no sense of humor. I think engaging with a sense of humor is the way to go, saying, whoa, all right, this is grounds that I'm not comfortable going here. I'm taking off. I'm going to Starbucks for a coffee, and literally extricate yourself from the conversation. It's light. It sends a signal without being overly heavy-handed or ham-handed, judging the others. That's kind of how I negotiate these sticky situations. So let's move on then. Maintaining a positive attitude is kind of an important piece because most likely when you start a job, you're going to feel a little bit like you're getting the grunt work. Everybody kind of starts at the bottom, especially if you're in a large organization. And my recommendation would be just keep upbeat, do what you're asked to do, and ask for more. And once you do the grunt work and do it with good humor, recognizing you're paying your dues, hopefully you will also get an opportunity to do more interesting and challenging work. And that really will kind of build as time goes on. Very much related to that is to treat more senior lawyers in your organization as your clients. By this I mean you're probably going to want to sit down and talk to the client. And if you're in a large law firm, you're probably not going to be allowed to. The senior lawyer is going to have the client contact, at least initially. But if you are very, you listen and try to serve the senior lawyer and ask, do what they want you to do, when they want you to do it, pretty soon you will build your reputation, will go forward. There's a few more just basic of these examples, and that is to remember you're the new person. This gives you a license to ask questions, so do it. You're not expected to know everything, and it's really a wonderful thing. Project confidence, not arrogance. This is important because you want the senior partners who are your clients, or if you actually have clients, individuals that you're meeting to have confidence in you, to trust you, right? But you don't want to go overboard and feel or project that you're arrogant.
Hey, Jayne, what about for those of us who are a little more shy, I don't necessarily put myself in that category, but a lot of people may be on the other side of projecting confidence there. What would you recommend they do? I know, again, just to go back to something that I experienced, I spoke to Roberta Liebenberg, who's the former chair of the American Bar Association's Commission on Women in the Profession, and she gave me this really great quote for an article that I just did for Student Lawyer, where she said, basically, it's okay to doubt yourself. Everyone in life has these, what she called imposter moments, where they just felt like, what am I doing here? I don't know what I'm doing. I'm really freaked out. What do you recommend people who may be having those kinds of moments do?
Oh, I agree with her 100%. I've had that for months, if not years, of my career. Honestly, it's kind of also what Sheryl Sandberg said in her recent book, Fake It Till You Make It, right? Lean into it. You may not feel that confidence, but you've been through law school, you've passed the bar, you're smart, and you will learn it. So part of that is just kind of pushing yourself to the interpersonal relationships that will match your intellectual prowess eventually. And yeah, especially for women, I would say, force yourself. It seems like, in my experience, that women sometimes underestimate their abilities on this particular point. You don't have to be arrogant, but quietly confident and move ahead, and step by step you'll gain that confidence. And always follow the ethical path. We're not going to spend a lot of time on this point. If you haven't taken your course on professional responsibility, you will soon. But here's something that's so very important to remember. Whether you have graduated or have been barred for 1 month or barred for 40 years, you must follow the same ethical rules. The rules of professional conduct apply to you, whether you have the confidence or experience of an older lawyer or not. So make sure that you're always taking care to hew to the rules. Very much related to that is to protect your reputation. There's a former Illinois Supreme Court Justice here, Tom Fitzgerald, who talked at some of the law school orientations for us, and he would often say, remember, your reputation is like a fine china vase, right? If it's cracked, you can repair it, but it's never going to be the same. The minute your reputation develops a crack, it's tainted. And it's very, very difficult to gain that back. So starting in law school and throughout your career, you need to protect that. And the last very practical piece of advice is really kind of related to number 6, find a mentor. You're the new person. It's okay to ask questions. And mentorship is really, really important.
Jayne, how did you go about finding a mentor when you were a young lawyer in law school, and how do you recommend students do that?
Well, unfortunately, I did not actually do as much in law school as I would have liked. But in my first law firm, because I felt very strongly what you talked about, Erik, the imposter syndrome, I went to various lawyers, either 1, 4, 5, 6, or more years out ahead of me, and asked my questions. I felt like I had to ask a lot of different people, because if I went to the same person, they'd really find out I knew nothing. But I was trying to hide my ignorance. In reality, what happened was a wonderful thing is I had a whole cadre of mentors, and I've kept them over the years. So, you know, it's good to find mentors in your organization. It's good to find mentors out of your organization, and keep that. You can start by asking questions, but then as you develop a relationship with them and a common interest, you give back. You can provide them some information and keep the relationship going. So moving on, I want to briefly touch on the fact that conflict is constant in the law, and the idea is not to avoid conflict or to be a doormat, but to recognize that you need to resolve conflict in a positive way. And in order to do that, you should kind of test into yourself, what is your default approach to conflict? If someone asks you to do something you really don't want to do, are you likely to say yes anyway and accommodate? Are you likely to jump down their throat and attack them? Or are you likely to just not answer and pretend you're not home or whatever? You really need to know, because I'm actually an avoider. They're all not very good, but it's nice to know what your natural approach is so that you can guard against it.
Yeah, just to jump in, Jayne, I think this is a really important point. Conflict is always around, even if you're not going to become a practicing attorney. It's around all the time in life, and I feel like just being aware of kind of the strategies that you can take, and also identifying, as you said, what kind of strategy you normally take, whether it's attacking it or avoiding it. I think a lot of people do avoid it. I know I certainly am guilty of that, but it's a really important thing to learn and to recognize, and I think just having that awareness of what type of way that you deal with conflict will help you in trying to deal with conflict in a better manner.
Yeah, we're going to get in a few minutes to some actual skills that will help you analyze your approach and maybe ways to diffuse conflict more productively. But first I want to tell you about Dr. Larry Krieger. Professor Krieger has done a lot of studies on professional identity and lawyer wellness and health. And he does an exercise with law students. Maybe some of you out there have done this exercise. I think it's fascinating. He tells his students, think about what your eulogy is going to be like when you're dead, you know, given by a family member or friend. What kinds of things do you want to be known for? And the things on this poll are what folks come up with. Like, she was caring. He had a great work ethic. You could count on him. She was a wonderful friend. Those are the kinds of things that are important to keep in mind, even in your professional capacity. He says that he's been doing this exercise for years and years, and never does a student say, he had a lucrative law practice, he was a powerful person. It's always these more relationship-oriented qualities. And it kind of comes down to, why do you want to be a lawyer? Why did you become a lawyer? You know, I think most of us are drawn to this career because we want to make a difference. I remember when I was a law student, and Erik, I'm going to ask you to jump back in because you told me something yesterday about this, but I remember being profoundly moved at some of those first and second year classes, con law and torts, about, wow, this is an incredibly important fabric to our society that I get to be a part of. I get to give voice to the voiceless, to make sure that all are treated equally in our country. It's kind of big stuff. It's heady stuff.
Absolutely, yeah. I mean, just to piggyback on that, I think I know personally. I know it's only anecdotal for my own experience, but I know a lot of people in my class who are at very smart, who are at the top of our class, who certainly could get a job at a big firm if they wanted to, but who are really more interested in doing public service work or going into the public sector, working for a nonprofit, something like that. It's not that there's anything wrong with working for a firm. I guess my take is that I was a little surprised coming into law school at just how many people really wanted to be an attorney for the right reason. Not to discount working for a firm, but they wanted to help people, and I think that was a little bit more prevalent than I expected coming into law school. I think your sentiment is spot on. There were a lot of my classmates who are really interested in doing work that may not pay that well, but that is, I think, they will find very fulfilling and satisfying.
Yeah, back in my day, when people went to law school, they went there because they didn't like the sight of blood and couldn't handle numbers. But now I think people realize that the practice of law is undergoing a lot of challenges now, and my experience from talking in law schools across our state is that people are really there for the right reasons, because they want to be there. And there is an obligation that we have as lawyers. Not only do we represent clients, but we also are an officer of our legal system. And then the third separate obligation is we have, as a public citizen, have a special responsibility for the quality of justice. And that is to work for reform, to urge people to understand the place that law can play in their lives. And it strikes me just in the last couple of weeks, as we've seen lawyers flock to airports on a pro bono basis to help people. This is lawyering at its best. This is the service and the civility and the professionalism that really makes me proud to be a lawyer. So let's move on to a couple of the skills that we teach actually in continuing legal education classes here in Illinois and across the country generally. So if we're talking about civility, we're talking about respect. And you show respect for others, as I mentioned earlier, by really exercising your listening skills. Listen to understand their point of view. So often when I was a young lawyer, I would be arguing a motion in front of a judge, and I knew what I wanted to say, and then I paused while the other side just yap, 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 and then I would have my rebuttal ready, but I wasn't really listening. So I couldn't really respect their point of view or be able to effectively counter the other side. So it's important to not only practice our oral skills, but our listening skills. And then the other piece of this is you might have to reframe your conversations to be more respectful. We're going to talk more about that in a minute. And then you can show your respect for yourself by refraining from taking the bait. So often people try to bait you to, come on, let's engage in this verbal diatribe and back and forth. And it is kind of fun. I remember you have these vigorous debates starting in law school and continuing throughout your career, but it doesn't have to be disrespectful or uncivil just to be effective. So what do I mean by reframing the conversation? Reframing is something you can do to your own words, and there's a lot of reframing skills. We don't have a lot of time, but we're going to talk about a couple of them here. If there's nothing you take away from this presentation in terms of civility and professionalism, listen for the word but. And I urge you to replace but in your sentences with yes and, or just the word and. What do I mean by that? Well, if you give a compliment and then say but, it really denigrates or takes away the compliment completely. I'm a very civil person, but sometimes I like to beat the heck out of you. Really, they're contradictory, right? And the everything before the word but is nonsensical or not remembered. So let's get rid of the word but and replace it with and. Erik, maybe we can talk about some of these back and forth.
Yeah, absolutely.
You're a new lawyer in my firm, and you've written me, a 10-page memo. I say the first 5 pages are very good, but the writing and organization deteriorate after that. You're feeling deflated, right? I mean, the but really stands out, and what you're hearing is, boy, my memo sucked. The writing and organization was bad. How could I reframe that in a more positive way?
So let's see. Yeah, I think you're absolutely right. What about saying something like, the first 5 pages are very good, and it would be great to see that same quality reflected in the last 5 pages as well.
There you go. Perfect. Yes. All right. I would like to grant your request for a day off, Erik, but we need all hands on deck for the partners retreat.
How about, I'd like to grant your request for a day off, and right after the partners retreat, please schedule a day off.
Okay, it's a little bit better, right? You're reframing it to be more positive. This is a tough one. I know your anniversary is tonight, but you need to stay here late to close this deal.
Yeah, that's a tough one. Let's say, how about, I know your anniversary is tonight, and once the deal closes, you can celebrate.
Great. I know you said your client is unavailable, but rescheduling him to Monday is unacceptable.
How about, instead of that, let's say, I know you said your client is unavailable, and Monday poses a problem for me. Can we get another date that works for everybody?
Okay. All right, that's great. I want to staff you on this case, but you just don't have enough experience.
Oh, that's one I never want to hear. That's rough. How about instead, I'd like to staff you on this case, and once you have a little more experience, we'll include you on the team.
Okay, more positive, more professional. All right, we'll keep going, and if anyone out there has any questions, Erik says just go ahead and type them in. I'm going to move on to that respect yourself by not taking the bait, okay? By that, I mean, if you get an angry email or a denigrating comment, don't write back angry if you're angry, and don't hit send right away. I started practicing law before, believe it or not, email, so this wasn't an issue. I would respond to a snail mail letter by dictating it, and I got a letter back from my secretary or assistant, and 2 or 3 days would have gone by, so I could reflect more objectively on my emotions and usually modified things, so they were more civil. But now you have to force yourself, when you're dealing with email, to review, reflect, and moderate. Picture your response as an exhibit to a motion to compel if you're being taken in front of a judge for being uncivil or unprofessional. And if the uncivil interactions are occurring in the course of an in-person meeting or negotiation, take a break. There's nothing wrong with saying, you know what, I'm going to go get a cup of coffee. Get up, remove yourself from the situation. And there's also nothing wrong with saying, I'm not prepared to respond to that right now. I'll do that later. Let's move on to paragraph 4 or whatever. Redirect and to kind of take control of the situation. Another little tip I've learned over the years is to put it in a parking lot, a figurative parking lot. If someone's trying to get you off kilter and says something that's kind of nasty, you could just say, you know what, that's not really on point. Let's put that sentiment in the parking lot. We'll get to it at a later time. And that way you've kind of taken control of the conversation, and you're not responding to incivility with incivility. So
All right, so I see we're hypotheticals here, Jane. Why don't we go over these real quick and let the audience vote on these, on their answers. I'll read them out, even though I know you guys can see them out there, but I'll read them out to you. So, receive an email from opposing counsel who represents a client with the same last name as you. After opening the email, you realize that it's meant for the opposing party. The email states, quote, "Deep, please review ASAP." The attached document outlines the reasons we could very well lose this case to Karen, as well as our previously discussed settlement strategy. So, what do you do in this situation? We have 5 options here, and I'll just go down the line real quick. 4 options, excuse me. The options are delete the email immediately, forward back the email without opening the attachment, read the attachment and delete the email, read the attachment and notify your opposing counsel of the misdirected email, or call opposing counsel and ask him he or she wants to do. So why don't you guys go ahead and vote on it now. While the audience is voting, Jane, what do you think about this scenario? What would you do with the document? Would you read it?
Well, I don't want to prejudice folks who are voting right now, but I'm not seeing a poll screen yet. Is Tracy going to do that?
There we go.
Are you seeing it?
I see it now.
Huh. Okay. Well, here, this situation is not exactly a civility deal, and it's not exactly an ethical, a straight-up ethical question. There's kind of a confluence of events here. The rules of professional conduct don't answer this question completely, and that's why we kind of included this in here, because it's a matter of professionalism and civility. Professionalism is what you should do. Ethics is what you must do in order to not get in trouble with your ARDC or your bar council in your respective states for violating the ethical rules. Now, Erik, I'm not seeing the poll results, so if you can tell me what you're seeing there, then we can...
Absolutely. Yes, it looks like about a quarter of the respondents said either delete the email immediately. That was 25% voted in favor of that. 25% voted in favor of call opposing counsel and ask what to do. And the largest response was half of the people that responded said forward the email back to opposing counsel without opening the attachment.
Okay, so we don't have number 3 or 4. Read the attachments as a very popular audience choice. Am I right?
Correct.
That's excellent. Okay, so there is an ethical rule that is somewhat on point here, and that's Model Rule of Professional Conduct 4.4. It provides that a lawyer who receives a document or electronically stored information, and they know or reasonably should know it was misdirected or inadvertently sent, shall promptly notify the sender. So we have this document. Clearly it was misdirected or inadvertently sent. So under Rule 4.4, the lawyer should notify the other counsel. Now, deleting the email is great, but you're supposed to notify the sender, and that's something that you will learn. Forwarding back with an email saying this was inadvertently sent, the vast majority of you opted for, which is awesome. It's professional, it's civil. It's what you would want someone to do if you inadvertently sent this, right? Because this could just tank your case. And you could call opposing counsel and say, do you want me to delete this? Do you want me to forward this back or whatever? Because that also complies with the rules saying notify the sender. What you should not do, and it's not clear that you should not do that under the ethical rules, but in terms of professionalism and civility, is read the attachment. Obviously, you're going to be reading a attorney-client privileged document that lays out the other side's case. So I'm thrilled that the responses came in the way they did. It sounds like the people on the line have a good moral compass about what they should do in a situation that's not directly unethical, and the rules don't specifically say what you should do. But that's great. It's great. Don't read it.
All right, why don't we move on to our second hypothetical here. So I'll read that out again. And again, if the audience members want to go ahead and vote, I'll read it out and give you a little bit of time to select your choice. But in this situation, you arrive in court, you're there on a discovery motion. During your opponent's, during the opposing counsel argument, he misrepresents his compliance with the discovery request. During your rebuttal, opposing counsel mutters a condescending remark that you can clearly hear, but that the judge does not hear. So in this situation, what do you do? So your first choice is ask the judge to have your opposing counsel repeat the remark, say nothing, and continue with your rebuttal. Tell counsel to stop interrupting you. Or fourth option, ask the judge to direct counsel to stop talking during your rebuttal. So go ahead and answer what you think is best there, and we'll take a look at the poll results, and then we will see what Jayne has to say about this. Now, we still got a few people voting. Jayne, let me ask you, though, I mean, it seems like the first option here is kind of calling out your co-counsel. Is that right?
Yeah, so, you know, this has happened. This happens a lot to young lawyers. You've got to be ready for more experienced lawyers to try to put you down, throw you off your game by muttering something or just not being professional or civil. It happens to women, it happens to minorities, and it happens a lot to young lawyers, unfortunately. This is not a situation where this behavior is unethical. It's not addressed in the model rules of professional conduct. This is something where kind of thinking through this scenario ahead of time and how you want to conduct yourself as a professional is really very important. And it also depends on your relationship with opposing counsel. Is this the first time this happens? Or you never met counsel before? Or has this been a pattern in practice over several months or even years? That might vary how you approach this. So Erik, because I'm not seeing the polls for some reason, can you tell me what we've got coming in, and then I'll
Absolutely. We had a good turnout. I think about 3/4 of the audience voted. So first response got 20%. That was ask the judge to have counsel repeat the remark. Second response got 30%. That was say nothing and continue with your rebuttal. And then there were no one selected tell counsel to stop interrupting you. And then the highest response was the last option, to ask the judge to direct counsel to stop talking during your rebuttal.
Okay, great. All right, so excellent responses for nobody saying tell counsel to stop interrupting you. As you all know, it's inappropriate to direct comments to counsel. If you've stepped up to the bench and you're facing the judge making your arguments, all of your comments should be directed to the judge, not to opposing counsel. So that's great that you had 0 on that one. Now, asking the judge to have counsel repeat the remark is something to do to draw the judge's attention to the condescending remark. You could say something like, Judge, counsel said something, I wasn't sure if you heard it. Maybe you could direct counsel to repeat the remark. And then the judge, if he really or she didn't hear it, might be surprised, but will take your lead, no doubt, and say, please repeat your remark. And then you could ask the judge, Judge, I'd like to ask you to rule on the propriety of that statement in court, depending on what it is. If it's you know, something that borders on, is denigrating based on, you know, sex or race or whatever, the judge could take some pretty harsh action against that lawyer. Now, if it's the first time, and I was guilty of this at the beginning, I would say nothing and continue with my rebuttal. That is perfectly okay if you want to give the guy or the woman the benefit of the doubt, if opposing counsel's having a bad day, or you never met him or her before, maybe they have Asperger's. You don't know what the condescending remark is, and if it's isolated and it's the first time, maybe you choose in that particular motion to say nothing and continue on with your argument. And then the asking the judge to direct counsel to stop talking is also completely appropriate, particularly if this is a repeat offender. I might say, Judge, I'd like you to please direct counsel to stop talking. I gave her the benefit of listening while he was speaking or whatever. And that's okay too. So the point here is there is more than one way to be a professional civil attorney. But you also have to be ready to draw some lines if opposing counsel is not being respectful and civil, and particularly call on the judge. That's the judge's responsibility to control the demeanor and behavior of lawyers and everyone in the courtroom. And if the judge didn't hear the remark, you kind of have an obligation to bring in the judge, and you'll feel better for it if you do it very calmly, very politely, but also firmly. So there's a lot of different ways. There's not just one approach. It kind of depends on your style and, as I said, your relationship with opposing counsel.
All right. So I think we want to open it up now to some Q&A. If any of the audience members have questions, please feel free to, I believe on the interface, you should be able to type in some questions here to ask us. In the meantime, while people are thinking of some questions they have, Jayne, I want to ask you a little bit, just, I don't mean to put you on the spot, but just curious, you know, as someone who had a career before in journalism, I saw a lot of really cool situations where people who were working on kind of opposite sides or competing would, at the end of the day, you know, put their things aside, put their work differences aside, and go out and, you know, get food together, get a drink together, whatever it may be. I'm curious, as someone who's new to the legal field, is that something that you've seen where people, even though you have to zealously advocate, you know, for your client, and you may be battling in the courtroom all day, is this something where you see a lot of attorneys who are who are on opposite sides of the, as it were, going out and having relationships outside of work?
Absolutely, and I would strongly recommend that you do it. I did it, and that is reach out to opposing counsel, go to lunch, or if lunch is too big of a commitment, meet for coffee. Say, we're on opposing sides of this case. I haven't met you before. You want to meet for coffee? I'm going to be at the courthouse Wednesday at 9 for a court call. I'll be done by 9:30, whatever. Truly, it is a very positive thing for your client to have an understanding of and a working relationship with opposing counsel. It does not benefit your client, as we saw from the surveys before, to have protracted litigation over minutia. That's not really advancing the case. There's no reason to do that, and it's important to go ahead and reach out to opposing counsel and have relationships there, but also educate your clients. You know what? I don't need to fight over his request to change the date of your deposition. It's the first time he made the request, and his mother died. I think that's reasonable. It's not advancing things. The judge is going to think I'm a fool and you are an idiot, and it's not going to help if I go into court and refuse and he files a motion. Something that's reasonable like that, we should agree on. And so to answer your point, Erik, yes, I think it's important to develop relationships with opposing counsel and also to educate your clients about why you're doing it. I've had more than one client say to me, well, why are you talking to opposing counsel? You know, I thought, you know, you're supposed to be fighting him tooth and nail. Well, yeah, we're arguing your case on the merits. I'm advancing your interest by getting to know him, understanding, you know, their client's point of view and what have you. You know, when 90% of the cases filed actually settle, it's really important to, you know, on a practical level, to understand what each client really wants and, you know, what the goal is here. and not let egos stand in the way of that.
Nice. I think we're getting a little low on time, but it is an interesting question I see here. So this one asks about what happens when you are on the other side. What if you're the one that's behaving poorly? The question is, how do you basically make amends? What do you recommend doing if you're the one that's having a bad day and maybe we're a little rude to the opposing counsel? Jayne, what do you think are some upper steps to kind of make up or make amends for that?
Well, I'm not proud to say that I was in that position more than once. Not a lot, but hey, everybody has a bad day. And I would say you pick up the phone and you call and say, listen, Jayne or Joe or Erik, sorry I lost my cool the other day, and I overreacted. I see your point of view. If you can, let's just put that behind us and move forward. Something like that. Now, it gets a little trickier depending on if you've behaved badly in front of clients or others. It's easy to apologize one-on-one, but it's kind of a basic human nature thing that you should compliment people publicly and criticize quietly one-on-one. And if you've lost your cool in front of other people, then you might take more amends than that. And you might need to say when you're in court the next time, Judge, I just want to say for the record that things got a little out of hand on my part last time when we were before you. I've since talked with opposing counsel. I've apologized for my behavior. We're going to move forward. And he'll or she'll be gracious and glad you're sending such a positive message there.
All right. I think we got time for one more. I see one here about asking about judge's role. I think what this question is getting at is perhaps in regards to the second hypothetical we did. Jayne, do you think it makes a difference to judges when they see lawyers behaving badly in the courtroom? Does that affect their kind of role in the process?
Yes, if you talk to judges, they hate seeing lawyer incivility and arguing over every scheduling issue or something that is inconsequential. They really hate it. They do talk amongst themselves. Oh, attorney so-and-so, yeah, oh my gosh, he's going to draw out everything. It's going to take every ounce of effort you've got to control that person. He's, full of diatribes and whatnot. So yeah, the judges will tell you they hate it. On the other hand, if judges are elected, they sometimes need to be reminded to take a firm hand because they can control the civility in their courtrooms, and sometimes they're reluctant to do that, which is what I raised with respect to hypothetical number 2. Sometimes you have to say, Judge, I think you should ask opposing counsel to repeat that remark. I'm not sure you heard it. In other words, do your job here, dude. So it's complicated, and it depends on, again, the judge's relationship, whether they're elected, whether they know counsel. And the other thing is, if you're in the same courtroom with the same cast of characters, if the judge is sitting in domestic relations and the same cadre of lawyers appear over and over and over again, you have to bear that in mind in terms of your tactics, right? You can either know that's going to make the judge more likely to be interventionist on this behavior or less, and argue or use your persuasive techniques accordingly. The judges are the key.
And I would imagine, and correct me if I'm wrong, but I would imagine that might, if you're just behaving like a total bore, I would imagine that might eat into your credibility a little bit as an attorney in front of judges as well.
Absolutely. And not only that, Judge, but, they're going to sit around and talk amongst themselves. So before you know it, all the judges in the courthouse that you practice in have a distinct impression of your reputation. And again, trying to undo that just because you behave so-and-so in a certain way in front of Judge so-and-so, you think that's going to stay there? No, it'll spread throughout the whole system. So you have to be very, very careful.
All right. Well, I think on that note, we're just about out of time, so I think on that note, we will wrap up. Before we go, I just want to thank everyone, first of all, for attending our webinar today. We really appreciate you coming in and joining us for a little while. There is a slide that should show us some upcoming webinars that I want to let you guys all know about. I think on March 9th, there we go, yeah, March 9th at 1 o'clock, we're going to have Steering Clear of Lawyer Discipline. That's always a good one and certainly related to this topic as well. And then after that, we have another webinar. These are free as well, like today's one. April 6th, 1 o'clock Eastern Time, Parameters of Practice for Law Students and Not Yet Licensed Graduates. Sounds interesting as well. It seems like a really good topic for law students to tune in on. So mark those in your calendar book. March 9th at 1 o'clock Eastern, April 6th at 1 o'clock Eastern. Those are free upcoming webinars from the ABA. And that concludes our program for today. So again, thank you all for joining us, and thank you, Jayne, for doing a wonderful presentation. I really appreciate it, and have a great day.
Thank you, Eric. It was a pleasure working with you. Thank you all for attending.
Likewise, thanks.